Okay, good morning, council. We'll go on the record in Haskell versus Haskell. This is file number 2218880. If I could have you both just put your appearances on the record, please.
Certainly, Your Honor. Zach Backlund on behalf of the plaintiff in this matter, Aubrey Haskell, who I was expecting to appear with us via Zoom this morning. I don't see her in the mosaic, though.
Good morning, Judge Elliott Blumberg on behalf of David Haskell, who is appearing via Zoom from my office.
All right, thank you. Yeah, Mr. Backlund, I do not see Miss Haskell. Did you want to try and contact her? Or did you want to go forward with the hearing today?
I think we can still go forward, Your Honor, and keep this thing moving.
Okay. All right. So we are on the record today for a status conference. We did have one scheduled last month. Parties agreed to adjourn to this month based on, I think, just some more time to get things finalized. So Mr. Backlund, on behalf of plaintiff, can you tell me the status at this point?
Yeah, we're trying, Your Honor. And Mr. Blumberg and I were emailing as recently as just a couple minutes ago to try and resolve this thing. You know, as you recall, we litigated a couple years ago now at this point, and the court found that the parties' previous agreements prior to filing were effective. What Mr. Blumberg and I have tried to avoid is entering a judgment and having these two just back in front of you consistently to iron out these gray areas. It's proving to be quite difficult. No fault to Mr. Blumberg. We're trying here. The issues seem to be the repairs. There's language in those agreements regarding repairs to the house in which Miss Haskell lives to be done by Mr. Haskell or paid by Mr. Haskell. The issue is that the language isn't clear. Mr. Blumberg and I are trying to clarify that again so these parties aren't just back in front of you litigating these issues. I know. Well, I believe Mr. Haskell also has issues with potential arrears. We've even been in front of you, Your Honor, regarding some of those arrears because there is spousal support and child support that are a part of this case. So we've tried to deal with those arrears and getting all those orders in place. We haven't had luck or we haven't been successful in eliminating that issue. Again, assuming that it's probably going to end up back in front of you, we would like to nip that in the bud if we could prior to entering the judgment. We haven't been able to do that. And so at this point, you know, this case has been going on for so long. I'm not sure if the court just wants us to enter a judgment indicating that the parties had these agreements and those are in effect. And we've been able to finagle a little bit of language in those just so that these two can be divorced. And if there are post-judgment issues related to what I just went over, then those get dealt with at that point. Or if the court wants us to try and continue, we've tried for quite some time now, and we haven't been able to reach a consensus. So that's where we're at.
All right, thank you. Mr. Blumberg?
Judge, I know the court has been very gracious in allowing us as much time as you have, and we really have not been derelict and not attempting to resolve the remaining issues. There have been proposals that were sent as recently as 30 minutes ago. We're trying to avoid the wrath of the court today because I know that you've been most anxious to have the case concluded, almost as much as the attorneys have. So I guess the long and short of it is what I had suggested to Mr. Backlund this morning was that we can prepare a judgment preserving a couple of the issues post-judgment in regard to payments made by Mr. Haskell in lieu of spousal support. I think that could be done. The bigger issue is the issue regarding the home that was awarded to Mrs. Haskell. She has been very reluctant to share information about what she wants done with the house. My client is prepared to pay for the materials for the repairs. The court had made an earlier finding that the parties would share the cost of labor for those repairs. Because we haven't heard back from Mrs. Haskell, my client made a cash offer to try to resolve that whole issue. And I think we're close, but we're not there yet. So I'm not trying to sidestep where we're at. I think we can get it done. I just don't want the court to be led on 30 more days and nothing get done. So um, I'm a little embarrassed that it's taken as long as it has, but it really is not from lack of effort by the attorneys in this case.
Okay. All right. Well, number one, I know that both of you have been working with your clients and making good faith efforts and diligent efforts to try and reach an agreement. You know, I mean, that's been obvious to me through the hearings that we've had and, you know, before those hearings, discussions I've had with counsel and chambers about how to proceed. So, you know, I would agree with both of you. I don't think that this is an issue of parties not being willing to try and resolve it, and certainly not the attorneys trying to work with their clients to reach an agreement. So I don't think it's a delay issue, but I do think, and I think it sounds like where you guys are at with this as well, is that we should get a judgment entered that resolves the issues that are agreed to and that don't remain out there. I think it's important for the parties at this point. I think Mr. Backlund said it to just be divorced and at least get that part of this case done with. I think that will at least narrow the issues. If in the interim there is an agreement, that's great. If not, then at least we'll have a judgment in place that we can all work from and address any outstanding issues to the extent that they aren't able to agree to it going forward. So my suggestion would be, and it sounds like counsel are able to agree on language for a judgment, perhaps not full interpretation of that language, but at least language. So my suggestion would be within the next 30 days for counsel to submit a judgment to the court. I don't know if you guys can remember, I can't. Have we taken proofs in this matter?
I believe we took the statutory proofs during our trial, which was December of 23, Your Honor. I think that was December 27th of 23 is when we had the hearing on those agreements of the parties. And I believe the statutory proofs were taken at that time.
Okay, so we don't have to worry about having another hearing outside of potential enforcement questions or motions. So Mr. Backlund, do you have any objection to proceeding that way?
No objection, Your Honor. We've been working on proposed drafts of a judgment, so it shouldn't take us too long, again, to get the parameters of it, understanding what the court just went over and the attorneys just went over regarding agreement about preserving some of the issues that remain here. But I think we can get these two divorced.
Okay, Mr. Blumberg, do you have any objection to that?
Absolutely not. That would be fine.
Okay, so that's how we'll proceed. I'm not going to schedule any further hearings in the case. So to the extent that the parties do need to come back before the court on the judgment, then that would have to either be scheduled by them individually or by counsel if they're still represented.
Okay.
Very good. Thank you.
Okay, thank you. So all parties are free to disconnect at this time.
Thank you.
Sorry, Mr. Vernon, I inadvertently connected you. I have one more matter that I have to take before your case.
Okay.
I'm just going to put you back in the waiting room for just a minute. Okay, Mr. Seeley and Miss Seeley, if you could both unmute, please. And we'll go on the record in Seeley versus Seeley. This is file number 2620373. The record should reflect that both parties are connected by Zoom video this morning. We are on the record today for a scheduling conference. This is a hearing where I kind of just touch base with both of you to determine whether there are any agreements between the two of you regarding the division of assets or debts of the marriage, or whether there are issues that are in dispute, and then what we need to do for scheduling in order to get those resolved so that the divorce can be finalized. So, Mr. Seeley, you're the party that filed for divorce in this case. I'll address those questions to you first. Are there matters currently in dispute between the two of you regarding the division of any assets or debts in the marriage?
No, sir.
Okay. You believe that the two of you have agreed on how to divide things up?
Correct. Yes.
Okay. Ms. Seeley, would you agree with that as well?
Yes, sir.
Okay. All right. So that'll make things a little bit quicker for the two of you. What I'm going to do then is schedule this for a final hearing. Prior to that hearing, there is a form called a judgment of divorce. And Mr. Seeley, did you go online, or how did you get your forms to file for divorce in this case?
Online and at the courthouse or at the clerk.
Okay, so in that same location online, you'll be able to get that final form. Again, it's called the judgment of divorce, and that's the final form that you have to file, and that's what I sign on the date of that final hearing to finalize the divorce. So I'll need you to get that form and fill that out and get that to the clerk's office prior to that final hearing date. And then at that final hearing, I'll place you both under oath, and then I've got some questions that I have to ask you under oath that are required under Michigan law to establish the grounds for divorce. So that's how we'll proceed. That hearing would be in about 30 days. And the court will send you both notice of the date and time of that hearing, just like we did for today's hearing. And that'll also be by Zoom, the same way that we're doing the hearing today. Mr. Seeley, do you have any questions about that?
I do not.
Okay. Ms. Seeley, do you have any questions at all?
No, sir.
Okay. So again, Mr. Seeley, it's important that you get that form and get that to the clerk's office prior to that next hearing. And again, we'll send you notice of the date and time of that. And you're both free to disconnect at this time. Thank you.
Thank
Thanks.
All right, we have everybody connected, so we'll go on the record in Horn versus Horn. This is file number 2620331. If I could have both counsel put your appearances on, starting with plaintiff, please.
Good morning, Your Honor. Thomas Weiss on behalf of Colleen Horn, who has joined me here in my office.
Adam Byrne on behalf of Greg Horn, who's present in my office, appearing remotely by Zoom.
All right, thank you. We're on the record today for purposes of a scheduling conference. Mr. Weiss, can you kind of just give me a status of where things are at and what you would like to have for scheduling going forward?
Well, yes, and thank you, Your Honor. We're early days. I'm with Mr. Horn's counsel briefly last Thursday in his office in Grayling, and we had a chance to discuss this case. I let him know that we are taking a good, serious look at a separate property issue that pertains to the property in Otsego County. And I'm in the process of gathering granting deeds and trust documents and that sort of thing. Our position will be that Colleen Horn inherited that property from her parents in her name only, and we'll try to collect sufficient evidence to be able to bring a motion for the court as to that separate property. We haven't exchanged any formal discovery, really informal discovery for that matter. And I think we both look at this, both counsel look at this, that we have 401ks. The home that they owned down here in Montcalm County was sold, and there's a substantial amount of cash that's on deposit, and that'll be divided. But I think other than collecting numbers on the marital property, the separate property issue is going to be where the big pole is going to be, and I would think that from our side, certainly just getting some interrogatories out, and probably a deposition to get into issues on the separate property elements. We'd probably be looking forward to that.
Okay. All right. Thank you. Mr. Vernon?
So we're looking for probably 90 days of discovery. I would ask the court to order mediation. Community mediation would be fine. If he's going to file a motion, I would ask for some time, either near the end of discovery or after discovery is closed, to file that so that we can have all the information necessary to make a proper response.
Absolutely. And no objection to mediation either, Your Honor.
All right. My thought would be to set a 90-day period for discovery, set Mr. Weiss for you a motion cutoff on the separate property issue of 120 days. So that would give you 30 days following the close of discovery. Because that's a legal issue, my question to counsel would be, do you want the court then to set a mediation cutoff following that motion, or do you want to have mediation? Typically I would order mediation during the time of discovery, but I understand that, with this legal issue kind of hanging out there, that it might be beneficial to have a decision on that before you go to mediation. But if the parties want to try mediation before that, I certainly would have absolutely no problem with that. So, Mr. Weiss, what are your thoughts on that?
I think you hit the nail on the head, Your Honor. The property in Otsego County is probably not hugely substantial, but there are 6 lots down there on Ranger Lake, is it? So if depending upon how that separate property goes, would materially affect the elements in a mediation. So yes, mediation after the motion, and the court has heard and decided that. Okay,
Mr. Vernon, do you have any objection to that?
No, I think that's appropriate.
Okay. So what I'll do today, for purposes of the scheduling order, again, I'll put in there that the discovery is to be concluded within 90 days, motion cutoff at 120 days for the separate property issue. And then I'll set this for a status conference also at 120 days. If for some reason there isn't a motion filed regarding separate property, then that gives us the next date. And at that point, I'll confer with counsel about a mediation cutoff date. So mediation's on the table if the parties, you guys can schedule it on your own at any point that you want to, but at that 120-day mark or a motion hearing, the court will set a mediation cutoff at that point, where mediation has to occur by a certain date. I'm not going to set that cutoff at this point today, because I think that's given the party's position that they want to have a determination on the legal issues first, I think that a mediation cutoff is too far out to set a realistic deadline for that at this point. So again, parties, if at some
Agreed.
point between now and 120 days, if you feel that you want to go to mediation, certainly do that. So I will put those dates into an order that'll go out to both parties. Also, the court will send a notice of the date and time of that next status conference at about 120 days. And Mr. Weiss, if you file that motion, then the court will reset that status conference for whatever date you get the motion for. Mr. Weiss, anything else we can address for your side today?
No, thank you, Your Honor. That'll take care of it. Thank you.
All right, Mr. Vernon.
No, Your Honor.
Okay, thank you. That's all for today, and both sides are free to disconnect at this time.
Thank you, Your Honor. Thank you, counsel.
Thank you.
All right, we've got everybody connected, so we'll go on the record in Cruz versus Cruz. This is file number 2319351. If I could have counsel put your appearances on, please.
Morning, Your Honor. May it please the court, Chris Kolumchek on behalf of the plaintiff and the moving party.
Judge Elliott Blumberg, I was the attorney of record during the underlying divorce case. I was contacted by Mr. Cruz over the weekend. He informed me he had been served personally with some pleadings on Friday and asked if I would get involved in this. I'm prepared to do that, but I don't know that the motion is timely given the date of the service of this matter. This is a post-judgment matter, and I think, first of all, personal service is required, and it needs to happen within 9 days of the actual hearing. I don't know that Ms. Cruz would be prejudiced if this was put off for a couple of weeks so that I can actually represent my client in this matter.
Okay, so you are going to go forward on behalf of Mr. Cruz, Mr.
Yes.
Blumberg?
He convinced me to stay on.
All right, Mr. Klomchek, what's your position on the service issue?
Well, regardless of my position, because I did serve Mr. Bloomberg in time, but he didn't come onto the case till after. I mean, regardless, I don't have any opposition to giving him time to prepare and we come back. Maybe we can even settle this amongst ourselves. But I'm just concerned that we keep coming back. And you know, my client understands that attorney fees aren't normally awarded, but it's getting to the point where this is ridiculous and expensive for her just to get a judgment enforced, and it cost us about $500 to have him personally served when he could have just had taken the motion from his attorney. But regardless, I don't have a problem waiting. Uh, uh, Obviously, it's a professional courtesy that Your Honor would probably expect any attorney to grant. So, in this case, obviously, we'd be willing to do that.
Okay. Yeah, I mean, I think it's a reasonable request, and I certainly, I understand Mr. Blumberg's position that even if he had notice of this, if he doesn't know whether or not his client wants him to continue representing him, he would have no reason to, look into it further or prepare for a hearing today. So I think it's a reasonable request. But I mean, I certainly agree with you, Mr. Klomchek. I know when I saw this case on my docket, it's like, all right, why are we back again? We have a judgment. Parties need to move forward. It's a pretty clear judgment, but certainly I will consider and address any arguments that Mr. Cruz may have to the extent that he hasn't complied. So, Mr. Klomchek, I'll just ask that you contact my office for another date, renotice the hearing, and then we'll go forward at that time. And so, Mr. Blumberg, that'll give you an adequate opportunity to talk to your client and prepare to the extent that the parties aren't able to reach an agreement between now and then. Mr. Blumberg, anything else for your side today?
No, Judge, thank you. I appreciate your consideration.
Okay, Mr. Klomchek, anything further from your side?
No, Your Honor.
Okay. All right, thank you. That's all for today, and both sides are free to disconnect this time.
Thank you, Your Honor.
Okay, looks like we have everybody connected, so we'll go on the record in the matter of the Court and Family Limited Partnership. This is Charlevoix County file number 03-1723-19-CB. And so for the record, we have Mr. Finling present by Zoom as the receiver in this matter. And if I could just have counsel put your appearances on as well, please.
Judge, it appears that I'm logged in twice, so I'm going to log out and log back in.
Okay, yeah, I can hear an echo there, so that'd be great.
Good morning, Your Honor. Howard Shear on behalf of Sheldon and Gail Korn and on behalf of Shauna Korn.
Good morning, Your Honor. Kevin Smith appearing on behalf of the Chapter 7 trustee Homer McClarty in the bankruptcy estate of Gail Korn.
Good morning, Dean Nelson representing Chapter 7 trustee Basil Simon, who is the bankruptcy trustee for Sheldon Korn.
And good morning, Your Honor. David Cleavorn appearing on behalf of Ashley Byron, formerly Korn.
Okay.
John Bowl, I'm the CPA that prepared the tax returns for the Korn Family Limited Partnership.
All right, thank you all. So we had our last hearing back in March. I did review my notes from that hearing as well as the status conference order that the court issued resulting from that hearing. At that time, we set this for a status conference in 90 days. And so in terms of an update and continued progress, Mr. Finling, as the receiver, if you would please start us off.
Certainly, Your Honor. So Mr. Bowl submitted all the tax returns that were required, but the IRS only recognized some of them as having been filed. Mr. Bowl and I worked through that, and an alternative plan for resubmission of the missing returns that the IRS did not indicate had been filed, even though he had done everything that had been requested of him. It's just that for whatever reason, the IRS didn't acknowledge receipt of some of the returns. I believe he's done that, and they've been, I don't know if the new ones have been processed, but I know the original ones have been processed. There's an attorney from the IRS who's involved that I've been communicating with, and I think Mr. Bowl has as well, with respect to enforcement by the IRS. I've drafted a letter after doing some research about the prohibitions about the IRS taking enforcement action while property is in the hands of a receiver. That will be going out shortly. And then lastly, just this morning, the discovery came in for Mr. Lenchner for the enforcement of the judgment that was entered. I think that brings the court up to speed if the court doesn't have any other questions of me. But I think that's everything that was expected of me, and everything's progressing as expected, Your Honor.
All right, thank you. Mr. Shear?
So, we had a status conference roughly 90 days ago, and the court entered an order that required the receiver to do two things. One, the receiver is directed to pursue collection activities regarding the Lenchner overpayment. And the second, the receiver shall continue to pursue abatement of IRS penalties for the filing of tax returns. So I guess I'd like to, this is a status conference, and so I think the court and the interested parties should understand exactly what's being done by the receiver in order to comply with those two things. So let's start with the Lenchner overpayment, Your Honor. The receiver overpaid roughly $150,000 on this amount owed on the judgment from back in the early 2000s. And as I recall, in October of 2025, so it's been more than 7 months now, the receiver obtained a money judgment from this court against Mr. Lenchner and his entities to recover that $150,000 plus. The court may recall, and it may be reflected in the court's notes, that when we had our last status conference, Mr. Finling told the court that he had prepared something, some sort of post-judgment supplementary proceeding, I guess under the revised Judicature Act, some sort of a petition or complaint that he told the court and the parties that he intended to file within a week or 10 days, something against Mr. Lenchner's son, Michael Lenchner, and some LLC, of which Michael Lenchner is apparently the sole member, called Jedi Group LLC. A few days after that, we had emailed Mr. Finling, and he had sent us a copy of some petition. I will tell the court it was not exactly clear to me what that petition was, but his email said, "I gave the petition to my staff last week to complete and file." So obviously, back from 3 months ago, where he informed the court and the parties that there was some sort of supplementary proceeding he was filing against Mr. Lenchner's son and this LLC, he did not do so. I don't understand why we're 7 months out, and it would seem to me that the most basic of things to do when you get a judgment, if you don't know how to collect on it, is at a minimum take Mr. Lenchner's, post-judgment creditor's exam, have him produce documents in connection with that. I think most of us have things on our computer that are just document requests, that would go with a subpoena for a post-judgment exam. I don't know why he hasn't done that. And he was very scant in what he just told the court he's done in the last 90 days. I don't know how clear that could have been to the court, but what he did do was send out 2 subpoenas to 2 separate banks, Citizens Bank, where he asked for documents relating to Jedi Group LLC for 3 years, 2021, 2022, and 2023. And then he sent a second subpoena to PNC Bank for documents relating to Larry Lenchner, Michael Lenchner, and the Jedi Group for those same 3 years. I think what he may have just said, or what I've heard from Dean Nelson recently, is that maybe he's gotten recently documents, bank doc records back on those 2 subpoenas. If so, I don't know. I mean, I'm not even entirely clear what the game plan was and what the use of those subpoenas was going to lead to as far as collection action. And in any event, I think it'd be appropriate to inform the court and the parties as to what those subpoenas have led to, if anything, of fruition. And in any event, what his game plan is. All we can do is go forward, but he was directed in a court order to pursue collection activities. And it seems like the only thing he's done since then is send out 2 bank subpoenas for some records that I'm not even sure what that plan is. And I think it would be appropriate before we go on to the tax return to maybe go back to Mr. Finling and find out where we're at, what his game plan is. Does he plan to file that post-judgment lawsuit he told us he was going to file 50 days ago? Is he sending out more discovery? Is he scheduling a creditor's exam? Like what is his plan, and where are we at?
Okay, I think that's a fair question. Mr. Finling, can you address those questions, please?
Yes, Your Honor. So the Proceeding Supplementary Judgment Act requires that the court set the matter for an early hearing. After reviewing the documents I had in my possession, I became concerned that I did not have sufficient evidentiary information such that I could satisfy my burden. The only bank that I knew about was Citizens Bank. I submitted a subpoena to Citizens Bank. They replied that the transactions involved PNC Bank. Then a second subpoena was sent out after receipt of the response from Citizens, and then they contacted me saying they're having difficulty locating the information that I requested. This morning, I received the response from PNC. So I have been diligently seeking to obtain the information. In my professional experience, and I filed hundreds of voidable transfer actions, I don't find any particular benefit in creditors' exams. I look at evidentiary information from banks because that is the best evidence with respect to a trust, to whether a transfer has taken place. I just got the information today. There has been no delay with respect to the effort I'm making, but the reason I didn't file the complaint at that, or the petition at that time, was I wasn't satisfied, and I thought I was. I wasn't satisfied that I needed more information. I've received it today, so I have to go through that, and then that should suffice with respect to my ability to file the petition. I don't know of any other enforcement efforts that I could make other than what I've done, which is during the last 90 days, I've investigated Mr. Lenster. I've looked at his ownership of the property on Arlington. I've looked at transfers between himself and his son. I've looked at title information from the Oakland County Register of Deeds. I've looked at DLAG with respect to the Jedi Group LLC and its operation. I've investigated Mr. Michael Lencher, who's an attorney, and the business that he's engaging in now. I've investigated with respect to the tenancy of Mr. Lencher, which continued after a purported foreclosure. And as I said, I've looked at all the real property information from the Oakland County Register of Deeds. I don't have any information other than that in my mind satisfies the specifics of what took place, which was checks were written to Mr. Lenster. They were deposited to a bank, which appeared to be Citizens Bank. That was the information that Flagstar had provided me. Flagstar is the bank that I use for my lawyer's trust account. I then pursued the information from Citizens, and they indicated that the account wasn't with them, and so that I had to follow up with PNC. I then sent a subpoena to PNC. Those are the efforts I've made, and I don't see any of those things as being delinquent in my responsibilities. I just didn't have all the information I needed to satisfy the petition. The petition's drafted. I told everybody that I had done that, and that was my intention. As I indicated, the problem with the statute is that the court has to set it for an early hearing, and I was uncomfortable filing it without the discovery necessary to satisfy my evidentiary burden. So now that I've received the information, I should be able to proceed. I can answer any other questions the court may have.
Okay, so that was going to be my next question. What do you anticipate your actions being in that regard over the next 90 days? What are your goals for continuing to pursue collection?
Right. So the Proceeding Supplementary Judgment Act has a very powerful remedy with respect to prima facie evidence when the judgment and the proof of the conveyance is included with the petition. That is that it's considered prima facie evidence and the burden shifts to the defendant. Now that I've received the actual documentary evidence, I have to identify the transfers, track them, and file my petition. That's not a significant effort other than just going through years of bank statements, but the petition itself has already been drafted, so I only have to identify the transfers from the bank information that's been provided.
Okay, so when do you anticipate that you would be able to get that filed?
10 days. And I apologize, I didn't mean to misrepresent to anybody about my intentions, but I realized as I was going forward that because the statute requires proof of the conveyance, and I have the wire transfers, but the information that was being provided by Citizens didn't match up, so I needed additional information.
Okay. All right. Mr. Scherer, do you have any further questions based on what we've just heard?
Hey, I'm flabbergasted. I think both Mr. Finling and myself have been practicing law somewhere in the neighborhood of 40 years. I've never heard any attorney say anything like, I don't find benefit from creditors' exams. I mean, you send a subpoena, you get tax returns, personal financial statements, information about, insurance that relates to assets, and that's a starting point, and then you have somebody under oath to find out whether you can send garnishments and writs of execution and get charging orders and do all sorts of things. The path he's about to head down is as I understand it, is some sort of fraudulent transfer action against Mr. Lenchner's son and this LLC, which hasn't filed an annual report, I think, since 2020, and have no idea whether that entity has any assets in any event, or what it is he learned to determine that there was a lack of consideration for a transfer from Mr. Lenchner to either of those two potential defendants. And at a minimum, I just can't imagine having somebody sit down and see if he's collectible. He paid the guy north of $2 million over these years. And I just don't know how you would not first try to find out whether there's, tax refunds, whether there's bank accounts, whether there's personal property that you could execute against, just any, I can't imagine he would say, don't find any benefit from taking a creditor's exam. That's, if you don't already have information about how to go do something, that's the first thing any lawyer ever does. And I can't imagine, instead of doing that, or doing that and doing what else he's doing, he's heading down a path that's going to lead to something that Your Honor is going to have to deal with some petition or lawsuit that, and he says it's based on records he just got this morning. I don't even know if he's looked at it and determining that it supports what he needed and didn't have 90 days ago when he told us he was going to do something in 10 days. So I'm just frustrated. And those are my thoughts.
Right, thank you. Well, let me just hear from the other lawyers first, Mr. Finling, and then we can go back to that. Mr. Smith, what's your view on the collection issue, if any, that's different than Mr. Shear's?
Your Honor, I really have nothing further to add. I do concur with what Mr. Shear has said.
All right, thank you. Mr. Nelson?
I also concur, and I just add the caveat that along the lines of what Mr. Shear was talking about, is that it's possible that Mr. Lenchner's son is going to come back and say that Mr. Lenchner owed him $500,000, and that's why these checks were transferred to him. And if that's the case and it's a valid debt, in my mind, I don't know if that's a fraudulent transfer to avoid, and then we're back to, well, what else does Mr. Lenchner have? So I am just very hesitant to put all our eggs in this basket, especially where it's $150,000. So other than that, I echo what Mr. Shear commented.
Can I jump in for one quick second? And during a creditor's exam, Mr. Lenchner, you could also ask him about these transfers to his son and or Jedi Group to try and understand where the money was transferred and what it was for, and whether there's a basis to go down that path.
All right, thank you. Mr. Cleveland?
Again, I concur like other counsel does. I think the only thing I would add from my client's perspective is, again, with the priority on moving things forward, I think there was kind of some concern articulated on what happens if the records this morning don't support the complaint or petition, and pursuing that route or something like that. And so if there's going to be some sort of court order that proceeds out of this, as far as, petition filed within 10 days or something like that, again, my main priority is to just try and keep this thing moving forward. So that's all I have to add on my end of things.
Okay, all right, Mr. Finley.
Thank you, Your Honor. I, as everybody was speaking, I was remiss to not mention that Mr. Bullock, who represents Mr. Lenchner, called me in a threatening way about the possibility of bringing avoidable transfer action. He indicated that Mr. Lenchner is impecunious, he has no assets, and so that colored my decision-making with respect to the most efficacious manner of bringing a recovery. I filed over 500 fraudulent transfer actions. I appreciate that Mr. Shear has a different experience, but when debtors show up for creditors exams, they know what they don't want to tell you. And I found them to be particularly difficult. They don't bring the documents that have been requested. They don't answer the questions that are being asked of them. And I believe that when I'm seeking recovery, I look to documents that I can rely upon. I'll take this creditor's exam if that's what I'm directed to do. But as I've indicated, I appreciate everybody else's experiences, and maybe that's their suggested path. But in the 38 years that I've done this, I've never had a creditor's exam where I found success, where they said, "Oh, I have a bank account with $100,000 in it, and here's the bank account information." If there's a bank account, it's empty. If there's an asset, it's been transferred. If there's a question they don't want to answer, they don't want to answer it. So I appreciate everybody else's comments, and if I'm directed to do it, I will. But my professional experience has not led me to the conclusion that it's of benefit to the estate to pursue that.
Okay. All right. Let's move on then, Mr. Scheer, to the issue of the taxes.
So, this tax issue, got highlighted when I had filed a motion on behalf of Shauna Korn to terminate the receivership estate, distribute money, et cetera, and both Dean and Kevin at least had, raised issues about concerns that, KFLP tax returns had not been filed for, almost 20 years. And the court's been aware of that since we all came down to Charlevoix for our first hearing and put the court on notice and Mr. Finling on notice that we were concerned about that they not only get filed, but that there was, a significant likelihood that penalties were going to be assessed, that were going to be somewhere around $180,000. And so we have made some progress, and, Mr. Bull, who we've all dealt with for many years and just think as highly as possible of and are so thankful that he's involved in this. The returns have been filed, as Mr. Finling indicated, and we've all been kept up to information on this in large part by Mr. Bull, that for some reason, some of the returns got processed and those led to the IRS sending out whatever pieces of paper indicated that there's now penalties being assessed and interest and things of that nature. And Mr. Bull could update the court if needed. I think they now have maybe all of the returns except for maybe 2 that he's hoping any day will get something back to show that they have those. But my concern is that on a number of them, penalties have been assessed, time periods have run, and now every single day that goes by, the liability on top of the principal amount for not filing the returns on time is growing every single day. And there is money in the KFLP estate that could pay those things, pay the penalties or, pay the late fee, whatever they all are, but the amount is even growing. And the path we wanted to go down was, other than Mr. Finling, the other interested parties believed that it was his responsibility to file the returns and his responsibility if the penalties, and fees and whatever there are not abated, that the next step's going to be to go after whoever should be responsible. I haven't looked into that. I don't know how the bond fits in and things of that nature, but I raised that very issue at the very first hearing. My questions were going to be, what's his game plan? Is he going to challenge, whatever they are, late fees, penalties, and if so, on what basis? And whether, at the status conference, find out whether he's hired somebody to help him. And during his introductory remarks at the start of the status conference, I heard him say that he's drafted a letter, that they've been talking to an attorney for the IRS, and secondly, that he's drafted a letter about prohibition of enforcement while there's a receiver, and that is going out shortly. So that is the first I've ever heard about that, and I'd like a better explanation of what that means, what he's talking about. Does that mean that's a basis to, because there's a receivership, that's a basis to argue that all of these penalties and late fees ought to go away? Or is that something that means the IRS has to come in and get leave of the court to go pursue? I mean, I just don't understand whether that's going to be the defense. You know, the interested parties care about that there's not 180 or 200,000 or some bigger number going out because these things weren't done timely, you know, during a time where there was lots of money in the estate to pay professionals to file the returns, and to pay any liabilities. So I'd like a better understanding of what that letter is, when it's going out, when he says going out shortly, and what he thinks that will accomplish, and otherwise have a better handle on what the game plan is going forward.
Okay, Mr. Smith, is there anything you wanted to add to those questions, Mr.
I have nothing to add. Thank you, Your Honor.
Thank you, Mr. Nelson.
You're muted.
Yep. All right. So along those lines, I believe from Mr. Bowl, which he could confirm, is that there are 2 that are outstanding, with the assumption that the IRS is going to issue the deficiency letter on those 2 returns. I would just hope and expect that Mr. Finley can hit the ground running in terms of any formal response to those penalties over and above what he may already have issued in terms of this letter. And so I would like some further explanation on what that plan is, if he has one yet, or if he's going to formulate it once all the penalty letters are actually received.
Thank you, Mr. Cleburne.
Nothing further to add, Your Honor.
Okay. Before I get to you, Mr. Finling, Mr. Bowl, if you wouldn't mind, I kind of saw you nodding your head when the attorneys were talking about what's left. So I'm assuming you're agreeing with what they've said, but can you just touch base on those questions that they've posed?
Yes, Your Honor. So on after numerous efforts trying to find what happened to the tax returns through the U.S. mail and making requests of the post office, we decided just actually a couple of weeks ago to send the 7 missing tax returns. We relabeled them as a second submission, never processed, because that's language that I obtained from some of the IRS agents that we talked to. They suggested that. So we sent the 7 returns in on May 15th. And very quickly, within about a week, they sent back 5 penalty notices on 7 of the tax returns and assessed additional penalties. The 2 tax returns that are still outstanding is 2007 and 2008. 2007, there's always been some doubt as to whether it actually did get filed many years ago. So it may have been filed, but we could never get confirmation of that. That was at a time when I think Mr. Korn still had the power to send in a tax return. 2008, the tax return got to the IRS on May 26th, so that was a week ago last Tuesday. So there still is an outside chance that they still may issue a penalty letter. And that's where we stand. The total amount of penalties to date now is approximately $144,000.
Okay. All right, thank you. Mr. Finley.
Thank you. So first I'd like to correct something Mr. Bowl said. 2007 was the year I was appointed. It's also the year that Mr. Horn, according to what we have, filed the 2007 tax return. I have a copy of it, and that's where the uncertainty is from Mr. Bowl, is that we don't know whether it was filed, but it was provided. With respect to the abatement, the difficulty I have is that I can't ask for an abatement for tax returns that have not all been filed. Mr. Bowl and I spoke about 3 or 4 weeks ago. I communicated with the attorney from the IRS to verify that he had all the returns. We found out that he didn't. We talked about the process that he had proposed for us to resend them. I think Mr. Bull and I communicated about that, whether he was going to mail them again or how he was going to proceed. He did that. And as of this date, all the returns have not yet been completely filed. So the difficulty with approaching the IRS for a set of returns that have not yet all been filed for an abatement is problematic. I can only do that for the entirety of the tax returns, because if I do it in part, then I'll have other tax returns that are not included in my request. So the only thing I've been waiting on is for all the returns to be with the IRS to request the abatement. There's no delay on my part other than waiting, because when we discovered that all the returns hadn't been filed, that prohibited me from seeking any relief from the IRS, because you don't ask for a request for relief twice. You make one request, because once it's been granted, they won't give it to you a second time. So for example, if I were to make a request for all the returns but for 2007 and 2008, and they were to grant it, they would not grant a subsequent request for 2007 and 2008. That's been my experience with the IRS. So I'm waiting for the fact that all the returns are still not in the hands of the IRS. I verified that with the attorney for the IRS, and Mr. Bull and I have been in communication. As he indicated, he submitted the second set on the 15th. He received his letter about a week later, which would have been the 22nd. And as of right now, we still don't have all the returns filed. So if the court, I don't know what I should do with respect to seeking abatement of some but not all of the returns, because I don't think that's in the best interest of the estate with respect to seeking abatement for part of what's owed. So that's the reason that I haven't taken any action, Your Honor, is that I don't have completed tax returns on file with the IRS.
So Mr. Bull, is it correct that the only one that we're not sure whether it's been filed is 2007, 2008 has been filed? You just haven't gotten the letter back yet, the penalty letter?
Correct, that is true. And, you know, with regard to requesting abatement and waiting for all the returns to be filed, at this point in time, I mean, I can estimate what the penalty is going to be for 2008 and 2007. My screen just went blank, but it's going to be, I think, approximately like $4,900 of penalty for each of those years. So, because what it is that every year the IRS establishes a penalty rate per month per partner. So in this case, with the corn tax returns, way back in 2007 and 8, they were charging $85 per partner per month. So that's 85 times 4 times 12. So it's pretty easy to kind of predict at this point in time the penalty amount for those last 2 years.
Okay.
Your Honor.
Well, let me just say one more question, then I'll get back to you, Mr. Scheer. How do we, like, if we're not sure if the 2007 was filed or not, I mean, can't you just refile it? Or, I mean, how do we find out what the status of that is so that we can have them all be filed? Or, I mean, can you not just, you know, I guess preemptively or proactively just refile the 2007 just so that we know that it's being processed and we're going to get the letter on that, the penalty letter?
Well, 2007 was refiled. It was part of these 7 missing returns. So 2007 was just refiled recently.
Okay.
And it did, and according to the tracking records of the U.S. Post Office, it did get delivered to the address in Kansas City. So we do know that.
All right. So really then the only thing we're waiting for are the penalty letters. But as you said, we really don't even need that because we kind of know what those penalties are going to be anyway.
Correct. Yes.
Okay. All right. So Mr. Finling, then how does that, I mean,
well,
is there a reason why we can't just immediately now pursue the abatement?
No, now that we have the majority, but for, and I would hope I'm clear about what Mr. Bull is saying, because the court had asked whether 2007 is the only one that isn't on file. And then I heard Mr. Bull say there's 2 years. So that doesn't change my role. I just want the record to be clear that at least what I'm hearing from Mr. Bull, that we have 2 years. If he could provide me with estimates of the amounts, I'll include the 2007 and 2008 and proceed accordingly. It was just the number that we had missing before was much more than that. And so now that he's received confirmation that everything but 2 has been filed, then I can proceed with making requests for an abatement.
Okay. All right, Mr. Shear, do you have any further questions on that?
I do, Your Honor. So the first point I was going to make was after Mr. Bull spoke, I think it was unclear to the court, and it's now clarified that 2007 and 8 are part of the 7 that were just sent in, and those are the only 2. Once they get it, we get the penalty letter, or, you know, whatever the letter is. So 2007 has been refiled. I think just to clarify the record, the parties are unsure whether the return prepared and signed back in 2007 was filed in 2007 or 8 for 2007 is being refiled again, but we'll find that answer out shortly. So I just, so that I'm clear, I still never got an answer as to what this Mr. Findling said when he said he drafted a letter about prohibition of enforcement while there's a receiver and would be going out shortly. And is that something different? We're talking about 2 things, that letter and a request for abatement. I mean, and I'd like, if we can get an answer, what the first letter is he talked about at the very beginning of this status conference. And then secondly, if Mr. Findling now says he's comfortable, he can go make a request for abatement, and assuming that's something different than that first thing, I'd like to know if he's already done some work to know on what basis he's going to request an abatement.
Okay, Mr. Finland, can you address that question?
Certainly, Your Honor. When the first set of returns were processed by the IRS, they submit an assessment. They can then proceed with administrative enforcement. The first letter that I was describing was during the interim period between when the first set of returns had been filed and accepted and the second set of returns had been filed and accepted. I wanted to ensure that the IRS wouldn't take administrative enforcement action to protect the assets of the receivership estate. So the reason I indicated that in that manner was that fact that I was holding off on seeking abatement because there was already an assessment, but not for all the returns. So the first part of my indication about the letter was to protect the estate. It is not intended as an alternative to abatement. It's simply to prevent the IRS from taking administrative action during the pendency of the receivership.
So that was just to hold off on taking collection action on the batch that was processed until the other batch. Okay, so now I understand what that meant. Okay. And then the second issue was, what's the basis that you're going to request abatement?
Certainly. So the basis is the very same thing that we've been talking about all along in terms of who ultimately had the responsibility for filing the returns, and the fact that there was uncertainty with respect to who would be responsible for it, and with respect to seeking abatement over that period of time. Essentially, it's equitable. There is no particular rule or standard that says you can or cannot do something, but essentially you make a request to the IRS seeking relief based on facts and circumstances that surround the lack of filing. So one could say that Mr. Corn prepared the 2007 return, and it was his understanding that I would file the remaining returns. I could say that Mr. Corn prepared the 2007 return, and I expected that he would do it. That lack of communication information would be a basis to say to the IRS, both sides are pointing at each other. There was an error in communication, and there was a mistake, and it wasn't filed timely, and now they're being corrected. So ordinarily, what the IRS is looking for is not the penalty for the lack of filing, because the filing is just for notice. It's not an official requirement with respect to an obligation of the partnership, because the partnership doesn't owe any money. The taxpayers, who are the partners, are the ones who owe the money. So the returns are simply the trigger for notice to the IRS with respect to what each partner was to receive. But ultimately, it's the partners who who may or may not have claimed the income on their returns, even though they were obligated to, whether or not the return was filed, it becomes their obligation. So what the IRS is really looking for from my communications with the attorneys from the IRS is that the partners pay their taxes on the money that was distributed, less so that the returns weren't filed timely. So those are the reasons I believe that there will be an abatement for the penalty, which is simply for late filing, not for any taxes that would be owed by Corn Family Limited Partnership.
Okay. All right. Mr. Smith, did you have any additional questions?
I have no additional questions, Your Honor. Thank you.
Mr. Nelson?
Nothing further.
Okay. Mr. Cleburne?
Nothing further on my end, Your Honor.
Okay. Mr. Scheer, did that raise any additional questions on your behalf?
I just, are we clear on when these two different letters are going out? And if there's an order that follows this, if there could be something that says those will be filed and provided to the parties at least, so that we see what he's filed, I think that would be satisfactory.
Okay. Mr. Finling, what kind of time frame would you have on that?
I'd say 10 days for the letter with respect to stay of enforcement. I'd say 30 days with respect to the request for abatement, because I still need information from Mr. Bull, and I haven't actually looked at the most recent assessment letter. And I also have to get the estimates from Mr. Bull with respect to 2007 and 2008. So I believe those are reasonable timeframes, Your Honor.
Okay. All right. So I'm going to issue. Oh, go ahead, Mr. Scheer.
I don't know the law on time deadlines on these things. And we'll be looking back to Mr. Finling if somehow a delay in asking for the abatement might get denied just on the basis that it wasn't made in a timely manner in relation to when these, assessments and penalties have hit. So if he's comfortable and believes he's okay waiting another 30 days, if it ends up being untimely, I don't want it to be that we all acquiesced and said, sure, fine, wait 30 days. I mean, I just want to be clear on that.
Yeah, no, I understand. And what I'm going to do is issue an order, number one, with regard to the enforcement. I want to consider what the parties have said today in terms of what I'm going to direct you, Mr. Finling, as the receiver to do in terms of the overpayment. And frankly, I want to look into that a little bit myself. So that what I direct you to do, Mr. Finling, is reasonable in light of all the circumstances and most likely to result in some results for the interested parties. And then with the abatement of taxes, I'm going to issue an order. I mean, I certainly understand your concerns, Mr. Scheer. I think in terms of the status conference order, that time frame is reasonable. However, Mr. Finling, I mean, I think, the sooner we can do that, the better. And to the extent that there are any issues arising out of that in terms of timeliness, the record is clear, Mr. Scheer, that I'm ordering what I'm ordering, but the parties may or may not be in agreement with the time frame that I'm ordering. So the record will be clear that it's not something that you're stipulating to or agreeing to. It's what the court is setting as a time frame. So the order will make that clear as well. And then I'm going to set this for another status conference in 90 days. But the order will incorporate what we've discussed here today, and will provide direction to you, Mr. Finling, again, particularly in terms of the overpayment issue. But otherwise, it'll reflect what we've indicated. Mr. Finling, is there anything else that you would like to address while we're on the record here?
No, I don't know that it will benefit the court for me to offer any other comment. Thank you, Your Honor.
All right, thank you, Mr. Scheer.
Nothing further. Thank you, Your Honor.
Mr. Smith?
Nothing further. Thank you, Your Honor.
Mr. Nelson,
Nothing further.
Mr. Cleaver.
Nothing further. Thank you, Your Honor.
Mr. Bull, was there anything else that you needed to address?
No, there's not.
All right, thank you. That order will be issued shortly. That'll go out to the parties along with the notice of the date and time of that next hearing, and all parties are free to disconnect. Thank you.